Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. Today we will be discussing torts, specifically negligent infliction of emotional distress. So let's jump right in with a hypothetical situation. Tony is texting while driving because he is distracted. Tony does not notice that Cynthia is crossing the street and he drives over her foot. As a result, Cynthia suffers a broken foot as well as post-traumatic stress disorder, resulting in sleep disturbances. Can Cynthia successfully sue Tony for damages related to her physical and emotional distress? The answer here is yes, under the theory of negligence. As a quick reminder, the theory of negligence arises when a defendant fails to exercise a degree of care that a reasonable person would in that situation, resulting in the harm of another. Negligence has 4 elements. First, the defendant must owe a duty of care to the plaintiff. Second, the defendant must breach that duty of care. Third, the defendant must be both the actual and proximate cause of the plaintiff's injuries. Fourth, the plaintiff must prove damages. For a more detailed discussion on negligence, check out our previous Listen and Learn episodes that we will link to in the show notes. Looking just to that final element of damages, a plaintiff must prove that they suffered physical or property damage due to a defendant's actions. A plaintiff can recover for emotional damages when combined with physical or property damages. So here, because Cynthia is suing for both a broken foot and emotional harm, she will satisfy that final element. Suppose, though, the facts change. Let's say instead of Tony running over Cynthia's foot, Tony drives within 2 inches of Cynthia's foot. Cynthia still suffers post-traumatic stress disorder and sleep disturbances as a result. In this situation, would Cynthia be able to successfully sue Tony for only the emotional harm? Well, historically, courts have been reluctant to allow liability for negligence solely for emotional distress. The thought was that this would open the floodgates and there would not be enough court resources to hear all cases whose damages are only emotional distress. Over time, courts have relaxed this general bar on recovery through the creation of Negligent Infliction of Emotional Distress, or NIED. NIED allows for plaintiffs to recover in instances where the only harm they suffered was emotional. This is not allowed in every possible instance where someone negligently inflicts emotional distress onto another person. Rather, it is only allowed in 4 very specific situations. I'll go through each one by one. The first NIED situation is if the plaintiff is in the zone of danger and suffers physical symptoms of distress. It has 2 elements. First, the plaintiff must be in what is called the zone of danger. The zone of danger is the area in which the plaintiff is at risk of being physically injured. You want to think about how close the plaintiff was to being physically injured. So, for example, if a child is struck by a car, the parent who is holding the child's hand but was not struck by the car would be considered in the zone of danger. However, if a child was struck by a car while walking to school by themselves and the parent was in their home, the parent would not be considered in the zone of danger. The second element is that the plaintiff must suffer physical symptoms of distress. This means that the emotional distress must manifest itself into some sort of physical symptoms. This element can be satisfied if the plaintiff suffers physical symptoms like a nervous breakdown, a miscarriage, or heart attack because of their emotional distress. The second NIED situation is if the plaintiff observes a close relative suffer physical harm as a result of someone else's negligence as it was happening and suffers physical symptoms of distress. There are a few key points about this situation. The first is that the plaintiff has to observe it. The plaintiff does not need to be in the zone of danger, but they do need to be a bystander. Second, this has to happen to a close relative of the plaintiff. Generally, being in the same nuclear family constitutes a close family relative. This means that if a man sees his neighbor, friend, or boss get injured, he cannot recover based on this theory. Third, the plaintiff must observe this as it is happening. It is not enough for the plaintiff to hear about the physical harm after the fact. The plaintiff must see it as it happens. Finally, the plaintiff must suffer physical symptoms of distress. The third NIED situation is if the defendant negligently damages the corpse of the plaintiff's close relative, and the plaintiff suffers physical symptoms of distress as a result. Similar to the second NIED situation, a close relative here generally means someone in the plaintiff's nuclear family. To understand this situation, imagine this scenario. Mother's wishes upon her death were that she would be buried. Upon her death, the mortuary negligently cremated mother's body contrary to explicit directions given by daughter. Daughter suffered from an anxiety attack as a result. Daughter would be able to recover for negligent infliction of emotional distress because the mortuary negligently damaged mother's corpse. Mother and daughter are considered close relatives, and daughter suffered physical symptoms of distress through an anxiety attack. The final NIED situation is if the defendant negligently misinforms the plaintiff that a close relative had died or was seriously injured, and the plaintiff suffers physical symptoms of distress as a result. Close relative has the same definition. It generally means someone in the plaintiff's nuclear family. As an example, imagine that Trish was admitted to the hospital because she suffered a stroke, but she is alive and recovering. When doctor goes to update Trish's husband, Paul, doctor accidentally mixes up patient charts and tells Paul that Trish has died. Paul suffered from a nervous breakdown as a result. Paul would be able to recover for negligent infliction of emotional distress because doctor negligently misinformed Paul that his close relative, his wife, had died, and he suffered from a nervous breakdown as a result. Before we try out some hypotheticals, I want to talk about one important distinction that NIED has with another tort, IIED. Negligent infliction of emotional distress is different from intentional infliction of emotional distress in one big way: the mental state required for each. Intentional infliction of emotional distress, or IIED, requires the defendant to have acted intentionally or recklessly in causing emotional distress. Essentially, the defendant must have known to some degree that their actions would have caused emotional distress. Negligent infliction of emotional distress, or NIED, requires the defendant to have acted negligently, in other words, carelessly, in causing emotional distress. Be careful when you are reading a fact pattern. Just because you see emotional distress does not always mean you should discuss NIED. Look to the defendant's mindset to determine whether the issue is NIED or IIED. As a recap, NIED is when a plaintiff can sue a defendant for negligently causing emotional distress. There are 4 situations in which a plaintiff can do this. First, if the plaintiff is in the zone of danger and suffers physical symptoms of distress. Second, if the plaintiff observes a close relative suffering physical harm as a result of someone else's negligence, as it was happening, and suffers physical symptoms of emotional distress. Third, if the defendant negligently damages the corpse of the plaintiff's close relative and the plaintiff suffers physical symptoms of emotional distress. And fourth, if the defendant negligently misinforms the plaintiff that a close relative has died or is seriously injured, and the plaintiff suffers physical symptoms of emotional distress, it is only in these situations where a plaintiff may recover under the theory of negligence for pure emotional harm. To see how well you understand NIED, let's work through some hypotheticals. This first one is adapted from the July 2010 California bar exam. Burglar went to the cinema parking lot with a loaded gun and used that gun in an attack on patron. Patron had just exited the cinema around midnight after viewing a late movie. During the attack, burglar approached patron and demanded that she hand over her purse. Patron refused. Burglar drew the handgun, pointed it at patron, and stated, "You make me mad, so now I'm going to shoot you." Patron fainted out of shock and suffered a concussion. Can patron successfully bring a claim of negligent infliction of emotional distress against burglar? Well, what do you think? You might be thinking that yes, of course, patron can. Patron suffered physical symptoms of emotional distress at the hands of burglar, so this must fit into one of the NIED categories. The answer, though, is no. Patron cannot recover on a theory of negligent infliction of emotional distress, although it is true that patron suffered physical symptoms of emotional distress by fainting and suffering a concussion as a result of burglar's conduct. Burglar acted intentionally. Burglar at least had knowledge to a substantial certainty that by pointing a gun at someone, they could suffer emotional distress. Thus, this would be a situation of IIED and not NIED. Remember the difference between IIED and NIED and try not to get them confused. So let's try one more. This next one is adapted from the February 2011 California bar exam. Gail went to Frances's house to help her move some paintings. Arriving at Frances's house, Gail carelessly parked her car several feet from the curb and entered the house. She came out later carrying paintings to her car. In a patrol vehicle, Paula, a police officer, spotted Gail's car. Frances caught sight of the patrol vehicle and told Gail, "Quick, move your car to the curb." Gail jumped into her car just as Paula was walking towards it. Suddenly, without looking, Gail swung her car toward the curb, hitting and severely injuring Paula. After Paula was transported to a hospital, she was visited by her husband, Harry. Shocked at Paula's condition, Harry collapsed and suffered a broken arm in the fall. Can Harry successfully sue Gail for negligent infliction of emotional distress? Well, take a second to think about the answer. Here, Harry will not be able to successfully sue Gail for NIED. This falls into the second category of NIED that I talked about. The plaintiff observes a close relative suffering physical harm as a result of someone else's negligence as it was happening and suffers physical symptoms of emotional distress. It is true that Paula is a close relative of Harry because they are married. It is also true that Paula suffered physical harm as a result of Gail's negligence. Additionally, it is true that Harry suffered physical symptoms of emotional distress because he collapsed and suffered a broken arm. However, the issue comes in with the "as it was happening" piece. Harry did not see the accident happen. He was not a bystander. He only saw Paula after the fact once she was in the hospital being treated by doctors. Because Harry was not there watching the accident, he would not be able to recover for NIED from Gail. How do you think we could change these facts so Harry could recover through NIED? There are a few ways. First, we could simply put Harry at the scene of the accident. If Harry was sitting in Paula's patrol vehicle or standing outside on the sidewalk watching the scene unfold, then Harry would have observed Paula's injuries as a result of Gail's negligence while it was happening. This would allow Harry to recover based on NIED. Second, imagine that instead of Harry visiting Paula in the hospital room, Harry was not allowed to see her and had to wait in the waiting room. After 4 hours of waiting, a doctor finally came out to give Harry the news. The doctor was very tired because he was on hour 10 of a 12-hour night shift. As a result, the doctor accidentally told Harry that Paula had died as a result of her injuries from the crash. Harry collapsed and suffered a broken arm in the fall. Harry would be able to recover in this situation as well. Remember that one of the situations in which a plaintiff can recover for NIED is if the defendant negligently misinforms the plaintiff that a close relative has died or is seriously injured, and the plaintiff suffers physical symptoms of emotional distress. Here, the doctor negligently misinformed Harry that a close relative, his wife, had died when she did not. Harry also suffered physical symptoms of emotional distress by collapsing and breaking his arm. Now that we have gone through some examples, let's go back to the hypothetical we began this podcast with. Ready for a refresher? Tony is texting while driving. Because he is distracted, Tony does not notice that Cynthia is crossing the street and drives within 2 inches of her foot. As a result, Cynthia suffers post-traumatic stress disorder, resulting in sleep disturbances. Can Cynthia successfully sue Tony for damages related to her emotional distress? What do you think? Cynthia could successfully sue Tony for the damages related to her emotional distress. This is because Cynthia was in the zone of danger and suffered physical symptoms of distress. She was in the zone of danger because Tony came within 2 inches of running over her foot, putting her in the risk area. Additionally, Cynthia suffered physical symptoms as a result of her distress through post-traumatic stress disorder and sleep disturbances. Okay, that's a wrap for today. Glad you could join me as we discussed negligent infliction of emotional distress. Thank you so much for watching. Please be sure to give us a like or leave us a comment, and be sure to subscribe so you don't miss any future content.